Hi guys. So now we're going to look at Wayfarer's, Lively's Dalbert motion against Wayfarer's. I've called her an intimacy expert, as that may not be like strictly what she is, but she is here to rebut specifically Michael Robbins. Um, I've had some amazing members of my community remind me of this guy because I did I did his report and I did his deposition, and what an awful man. Honestly, this is a guy who shredded his notes. He shredded his notes. He was incredibly rude and combative in his deposition, and his report was just a pile of shit, to be honest. Absolutely. Oh. Anyway, so yeah, so this expert is Anne Fromholz. Again, I'm not good with names. Everyone should know this by now, so hopefully I've said that right. It's quite a bit longer actually. It's more than twice as long as the other Wayfarer expert I've already covered this morning. And it's considerably more detailed. I mean, for a start, we have a table of contents and a cases citation list as well, which is impressive because we didn't have that with the last one. But I think this is going to be funny, but not Wayfarer snark funny. I think it's just going to be funny because I'm expecting Lively's counsel to be quite combative here because they're going to want to keep Michael Robbins as an expert. Okay. So, preliminary statement. Defendants seek to rely on expert testimony from Anne Fromholz to rebut the opinions of plaintiff Blake Lively's highly credentialed workplace policy expert Michael Robbins. Here we go. But Fromholz's opinions cannot survive scrutiny under Federal Rule of Evidence 702. They are untethered from the remaining claims in this case, contrary to governing law and recognized workplace and investigative standards, unsupported by any reliable methodology, and at critical junctures, based on selective facts, misstatements of the record, and improper legal conclusions reserved for the court. Fromholz's opinions are irrelevant and unhelpful to the trier of the fact. Following the court's April 2nd summary judgment order, Miss Lively's retaliation, but not her harassment claim, remains. Fromholz ignores Miss Lively's retaliation claim altogether, opining only that it was not necessary to investigate any complaints of harassment because, according to her, no harassment occurred or recurred, and a hypothetical investigation would not have supported harassment claims. I mean, Lyman barely supported them. And I think that is relevant. She has to have, as much as Lively is trying to skirt this point, she doesn't have to prove definitively sexual harassment, but she has to prove that she had a reasonable basis for believing that she had been sexually harassed and complaining about it. So, an expert saying nothing that she complained of would have given rise to sexual harassment is relevant. It wouldn't defeat the claim, but it's important. Okay. As the court held in the order, whether the complaint of conduct amounted to harassment is immaterial to a retaliation claim. Yeah. So long as the employee acted with a good faith, reasonable belief. Accordingly, Fromholz's testimony requires exclusion because it will not assist the trier of fact and instead substantially risks confusing the issues. Fromholz's opinions separately require exclusion because they are unreliable. She opines that no investigation was necessary based on the outcome of a hypothetical investigation that never occurred, makes credibility determinations without interviewing a single witness, and failed to review the available evidence and testimony, relies on a cherry picked and incomplete record supplied by defendants, and disregards investigative standards, including those she herself elsewhere endorses. In doing so, she repeatedly departs from the California Civil Rights Department Harassment Prevention Guide, Wayfarer's own policies, and her stated investigative practices. Finally, Fromholz is unqualified to opine on the core aspects of this case, including entertainment industry intimacy protocols and the reputational impact of post-employment conduct on actors. She concedes she has never worked on a film set, engaged with an intimacy coordinator, or negotiated a nudity rider, and that her views on reputational harm are based solely on anecdote and media consumption. And just to balance that, this is the competing view. So they're saying, well, look, she's never worked on a film set, she's never engaged with an intimacy coordinator or negotiated a nudity rider. I think it's fair to point out that neither has Michael Robbins. He worked on a TV set 30 years ago for, he worked for a production company, I think it was, over 30 years ago for 2 years. He has never, worked with an intimacy coordinator. He's interviewed on one occasion for advice. That's it. And he has never negotiated a nudity rider either. So, Rule 702 does not permit Rule 702 does not permit expert testimony built on speculation, selective reading, or generalized impressions. Because Fromholz's opinions are unhelpful, unreliable, and at points inadmissible legal conclusions offered by an unqualified witness, her testimony should be excluded in its entirety. Background. Fromholz intends to offer 4 opinions purporting to rebut Robbins's opinions. Fromholz intends to offer 4 opinions, right? Okay. 1. Robbins erred in his conclusion that Wayfarer failed in its obligation to conduct an investigation into concerns that Lively raised during the filming of It Ends With Us, because Wayfarer, Baldoni, Heath, and other defendants took immediate action to correct and prevent conduct about which Lively complained, and therefore an investigation would have been superfluous. Right, the investigation, I am struggling with that a bit because, okay, let's just take the sexy comment, right, or the hot comment, one of them, yeah? Lively goes to, say, Alex Sachs or Angie Giannetti, right, either of, and says, look, don't like this comment that Justin Baldoni made to me. That person then relays that message to Justin Baldoni and says, hey, you made Blake Lively uncomfortable with your comment. Justin Baldoni responds and says, oh, right, okay, sends an apology and says that he will correct course. What more is there to investigate about that? Like, why do you need a whole damn investigation? Because to do what? To have someone formally interview Justin Baldoni? Did you say this comment? To do what? Because Jenny Slate, went through the same process for the same reason and was satisfied that the issue was resolved. So, is it so complicated that it needed an investigation? The person who was offended is identified. The act that was, considered offensive is identified, and the person who allegedly offended that person is identified. They have apologized and said they won't do it again. What more is needed? What more is an investigation going to churn up? This is me just thinking aloud. But I like to share my thoughts with you guys because I like to see the kind of comments, like people's own thoughts and counter thoughts. But do you know what I mean? Like, Yes, but in many cases, an investigation should be carried out. But are these situations, these scenarios, so complicated that they need a whole investigation? Let's continue. Robbins erred in his conclusion that Wayfarer failed in its obligation to conduct an investigation because an investigation would have shown that a preponderance of the evidence did not support Lively's allegations. 3. Robbins erred in his conclusion that Wayfarer violated entertainment industry specific intimacy protocols by failing to require an intimacy coordinator to be present on set during phase 1. Oh yeah, because it's not essential. It was just a recommendation from SAG-AFTRA. It was not essential at that point. I don't think it's still essential now. Failing to have a signed nudity rider in place in phase 1, and allegedly failing to have a closed set during the birthing scene. I mean, Wayfarer saying that there was a closed set. Robbins erred in his conclusion that the entertainment industry is unique in that post-employment actions that affect a person's reputation can harm their future job prospects. The opinions purport to refute the 3 opinions offered by Miss Lively's expert Michael Robbins, who brings nearly 5 decades of experience in workplace practices and investigations. 1. Defendants failed to follow standard practices and their own policies and procedures with respect to preventing harassment and retaliation from occurring relating to the movie It Ends With Us, including by repeated failures to investigate harassment and retaliation allegations raised by plaintiff Blake Lively and at times by others on the film. 2. Defendants failed to follow standard practices with respect to preventing harassment and retaliation from occurring, including by violating entertainment industry-specific intimacy protocols that are designed to prevent harassment from occurring and to ensure a safe environment for all involved. 3. The unique nature of the entertainment industry and how an actor's career in the industry can be affected both before and even after the project on which she is working has been completed. Okay. So, Fromholz has limited background on workplace practices in the industry. Although she has practiced employment law for years, none of the cases in which Fromholz has provided expert testimony pertain to workplace investigations within the industry. Fromholz conceded that she has never 1. Worked on a film set, 2. Worked with or spoken to an intimacy coordinator, 3. Negotiated or drafted a nudity rider, 4. Represented a film or TV studio in litigation, 5. Served as an expert for an entertainment client, or 6. Opined as an expert on intimacy issues. Fromholz relies on the CRD guide to support her methodology. Fromholz points to 3 data points that can support the sufficiency of an investigation. 1. Legal obligations. 2. The factors in the CRD guide. And 3. Her own experience. While there are various standards, Fromholz's own cited CRD harassment prevention guide for California employers provides irrelevant part. What an employer should do upon receipt of a complaint. If the report contains allegations of conduct that, if true, would violate the company's policies or the law, the employer must investigate. Obligation to investigate. Investigators should start the investigation promptly. It is rarely appropriate for an employer or investigator to fail to investigate a complaint simply because an employee says they will address the problem themselves. Basic steps for a fair investigation. Interview relevant witnesses and review relevant documents. Get all the facts. Reach a reasonable and fair conclusion about what happened. Recommend practices for investigations. The investigation should be impartial. factual findings should be based on objective weighing of the evidence. It is not uncommon for there to be no direct witnesses, in which case the investigator must make determinations about the party's credibility by using factors such as motive to lie and inconsistent statements. Counselling against retaliation. Employers should tell witnesses that retaliation violates the law, and their policies should counsel all parties and witnesses not to retaliate and should be alert to signs of retaliation. Prior to her retention in this case, Fromholz publicly emphasized practices that aligned with the CRD guides, stating, for example, that a company must investigate promptly and regardless of whether the complaining party chooses to participate. Legal standard. The proponent of expert testimony has the burden of establishing it is admissible. Expert testimony is only admissible if it is 1. Made by an expert with sufficient qualifications, 2. Reliable, and 3. Relevant. Whether a witness is qualified is a threshold question that precedes the court's relevance and reliability inquiries. It is critical that an expert's analysis be reliable at every step. In deciding whether a step in an expert's analysis is unreliable, the district court should undertake a rigorous examination of the facts on which the expert relies, the method by which the expert draws an opinion from those facts, and how the expert applies the facts and methods to the case at hand. Where an expert opinion is based on data, a methodology, or studies that are simply inadequate to support the conclusions reached, Daubert and Rule 702 mandate the exclusion of that unreliable opinion testimony. As for relevance, the inquiry is whether the expert testimony will assist the trier of fact to understand the evidence or to determine a fact in issue. The Second Circuit has consistently held that expert testimony that usurps either the role of the trial judge in instructing the jury as to the applicable law, or the role of the jury in applying that law to the facts before it, by definition does not aid the jury in making a decision. Rather, it undertakes to tell the jury what result to reach, and thus attempts to substitute the expert's judgment for the jury's. Likewise, an expert cannot provide legal opinions, legal conclusions, or interpret legal terms. Those roles fall solely within the province of the court. Fromholz's first opinion requires exclusion pursuant to Rule 702A and C. Fromholz's first opinion fails to assist the trier of fact. Fromholz's first opinion fails to assist the trier of fact under Federal Rules of Evidence 702A because it no longer addresses a viable cause of action following the court's order which granted summary judgment as to the harassment claims, but not as to Miss Lively's Fair Employment and Housing Act retaliation or aiding and abetting claims. Well, not yet anyway. Watch this space. Fromholz opines that an investigation would have been superfluous because after Miss Lively's protections for return to production, a document that Miss Lively sent to Wayfarer in November 2023, in which she requested that Wayfarer agreed to implement 17 demands for her own staff as part of the crew, 17 protections to ensure safe set going forward, and as to which she was willing to forego a more formal HR process, no allegations of misconduct took place during the second phase of filming. Well, that's true. It didn't. But that opinion addresses only Miss Lively's complaints made during production, while ignoring anything that followed, including the retaliation campaign. Fromholz's first opinion is limited to only harassment, which not only leaves out the current viable claims, it also ignores that Robbins opines on the failure to follow practices and policies to prevent harassment and retaliation. It thus fails to correspond to Miss Lively's remaining claims. Fromholz's first opinion is an incorrect legal conclusion. Fromholz's first opinion also fails to assist the trier of fact under Federal Rules of Evidence 702A because her opinion that the defendant's corrective actions rendered an investigation superfluous and lived up to their legal obligation because they ensured that the unwanted conduct did not recur is an incorrect legal conclusion. Unlike Robbins, Fromholz is not opining on a failure to follow standards and policies to prevent harassment and retaliation. Instead, she opines far beyond Robbins' mandate by expressing opinions on whether the law, as opposed to standards and policies, required the defendants to perform an investigation into Miss Lively's harassment complaints. A rebuttal expert report such as Fromholz's report is not the proper place for presenting new arguments that prejudicially shift the legal framework. And Fromholz may not give testimony stating ultimate legal conclusions as she purports to do here. Even assuming arguendo, Fromholz could opine on the law, she wholly misstates the legal standard. Expert opinion that is incorrect as a matter of law and conclusions drawn therefrom cannot help the trier of fact to determine a fact in issue. Fromholz's legal conclusion that the defendants somehow lived up to their legal obligation without performing an investigation is far afield from employers' affirmative obligation under the law to promptly investigate misconduct complaints. Any conclusion otherwise runs contrary to well-established precedent. Significantly, Fromholz's conclusion that simply agreeing to the 17 protections corrected and prevented conduct is flatly wrong. Fromholz ignored the retaliation campaign that followed the defendant's failure to investigate complaints, and the law is clear that the failure to conduct a rigorous investigation may be compelling evidence of an employer's retaliatory animus or malice. For example, in Mendoza, the court found that an employer's numerous shortcomings with respect to an investigation following an employee's harassment complaint may be considered evidence from which to infer retaliatory animus for firing the employee after making such complaints. A failure to conduct an investigation may also support a finding of ratification for the purposes of punitive damages. And even in Title VII cases under which no independent failure to prevent cause of action exists, courts consider a failure to investigate as relevant in the context of punitive damages. It is undisputed that there was no investigation at all here, much less a rigorous one. Fromholz's first opinion is unreliable. If the court reaches reliability, the first opinion must be excluded because it is methodologically unreliable under Federal Rules of Evidence 702C. When, as here, an expert ignores evidence that is highly relevant to his conclusion, contrary to his own stated methodology, exclusion of the expert's testimony is warranted. Fromholz's opinion is based on multiple faulty steps. 1. Replacing the 17 protections with a more formal HR process. 2. The 17 protections, it did say willing to forego. She's willing to forego. She's moaning that there's no investigation, but in her own letter, she said that she is willing to forego if Wayfarer do all this. And all that she can say has been breached at the end of all of that, or she's trying to argue it anyway, is the bit about retaliation, which, she says occurred in August, but she didn't even know about it before the very end of August, by which time the production and everything was all done. The movie was released. There was no more marketing. I mean, the set had ceased to exist. So what are they going to investigate? Right. Okay. Faulty steps. Replacing the 17 protections with a more formal HR process. 2, ignoring the retaliation to find that none of the allegations of misconduct in the complaint took place during the second phase of filming. And 3, finding that corrective actions rendered an investigation superfluous. Right. This is really annoying me. So I'm just going to work this through in my head now, right? So she's complaining in 2023, June 2023, she's complaining she was sexually harassed. She did mention it. Wayfarer did respond, apology, blah, blah, blah. She then, for some reason, unprompted and unprovoked, said, look, I'm not coming back, right, unless you meet my ransom request here. The 17-point list, right? That was in November. She then claimed the all-hands meeting was also a protected activity. I dispute this because there was no notice that was the purpose of it. It was not on neutral territory. All the relevant people that should have been there, not all of them were called. In fact, she only invited Justin Baldoni and said he could come on his own. So that's not an all-hands meeting. And to me, it's not a protected activity either. It was an ambush. And then she goes back to filming in January, finishes the filming in February, says everything is fine. Right? So at that point, she's still willing to forego the HR process because, they've met her demands. There's been no further issues. All is well. So there is no need for a HR process at that point. But she's saying then, well, in August, my reputation tanked. So at that, I know, and it's all Wayfarer's fault. They retaliated against me. And then, despite the fact that she didn't actually come back to them and say, hey, you're retaliating against me. You need to, you breached this term of the agreement and you now need to start a formal investigation. Despite the fact she never spoke to them again. She didn't get her lawyers to send anything. She didn't have to do it herself. She could have instructed her lawyers to send something, right? She didn't actually send the cease and desist until December. The day of or the day before that she sent a CRD complaint to them. So at what point, and this is part of what Judge Lyman said was, it wasn't the motion for summary judgment. I think it was, I can't remember what it was, but it was something else. But she didn't actually give them like the notice period to remedy anything. Because she sent the cease and desist and the request to correct everything. And then about a week later, if that, maybe 10 days later, she filed her lawsuit. So at what point, I'm struggling to see at what point they were expected to have conducted an investigation. Because she's claiming that everything was fine up until the retaliation at the end of August. Well, in August. And then she hasn't gone back and said anything at all. She is saying, well, and I think they're quite literally assuming because it was Melissa Nathan who was hired that, there's retaliation. They don't actually know. They knew nothing at this point. And they didn't find out anything until the end of the month when Stephanie Jones handed over the phone. And from there on, it's still speculation. But, she didn't go back and say, hey, Wayfarer, you breached this. You need to now do an investigation because, you're violating your own company policies. And in fact, she didn't actually respond or say anything to Wayfarer until December. And it was in December that Wayfarer actually did initiate that side investigation from that law firm. We're not going to get to hear about that because Wayfarer, it was a similar situation as to Blake Lively when she, with her intentional infliction of emotional distress. Wayfarer wanted to do discovery. Lively said no. Judge Lyman was like, that's fine, but then you can't claim it. you can't bring evidence, you can't testify to intentional infliction of emotional distress. You can only testify to garden variety. And the same thing happened. Wayfarer, there was a back and forth, a motion to compel over Lively wanted all the details of the investigation. Wayfarer said no. The judge said, that's okay. You don't have to hand it over to her, but you also cannot present that as any evidence either. And I think they agreed to that. And that's why we've not heard about that investigation since. And it won't come up here. But I'm looking at this timeline, right? And this is Lively's own kind of timeline. I'm struggling to see where, at what point, if she is now saying that, because this is what, I don't know if it's just me, it makes sense in my head, right, that there would have been no investigation necessary for the quote unquote alleged actions of sexual harassment that as she states they are, because everything was fine. And she herself expressly stated, I'm willing to forego a formal HR, which is an investigation, by the way, in case Lively didn't know that. That is the definition of, that's what an investigation would be, a more formal HR process. And she's willing to forego that in November 2023, months after the alleged sexual harassment. So she can only be saying, well, and nothing else happened, nothing else went wrong, there was no further incidents, by Lively's own words. Then the only thing she can say is that warranted the investigation was the retaliation. But that was in August, and Lively never said to Wayfarer, you violated this and you need to do this, until December. And in December, upon the CRD, they did actually initiate an investigation. So I'm not quite sure why Lively keeps saying they failed to investigate, because by my calculations, they did not. Does anyone else agree with me? Am I making sense here? I'm trying to math this out in my head, but Lively is confusion. She's really confusing. Let's continue. So each step is contrary to her 3 data points she uses to assess the sufficiency of an investigation. 1, legal obligations as set forth supra. 2, the CRD guide. And 3, her own experience. First, Fromholz's conclusion is that the 17 protections were in lieu of a more formal HR process, because it said that. Fromholz, right, okay. Fromholz's conclusion that the 17 protections were in lieu of a more formal HR process is directly contradicted by the CRD guide, Wayfarer's workplace policies, and Fromholz's own practices. Let's just take that apart a minute, yeah? The 17 protections were in lieu of a more formal HR process, because that's what Lively said, right? And then the first thing that Lively here is pointing to is saying, well, hold on, it's contradicted by this, is our CRD, and here in the air quote, guide. It's a guide. Wayfarer's workplace policies, again, it's a policy, right? It is not mandatory. And it is also directed by the person making the complaint. So if Lively is saying, look, I'm going to forego a more formal HR, then that supersedes both the CRD guide and Wayfarer's workplace policies. And Fromholz's own practice, well, what the hell has that got to do with anything? Because she wasn't there at the time. I'm getting annoyed now because this is just so disingenuous. Despite standards and her own practices otherwise, she strongly concludes that the Wayfarer defendants took immediate action to correct conduct about which Lively complained by passively agreeing to the 17 protections. The CRD guide states it's rarely appropriate, not never, just rarely appropriate for an employer to forego an investigation simply because an employee says they will address the problem themselves, and that an employer must investigate allegations of conduct that, if true, would violate the company's policies or the law. Fromholz conceded that the failure to investigate was not consistent with every step of Wayfarer's own workplace policies. Right, again, they keep citing Wayfarer's workplace policies. We have to remember that Lively was, working for It Ends With Us movie. And yeah, okay. I know there's a dispute over whether they are one and the same as Wayfarer, but for legal purposes, they are not. And she signed the agreement with It Ends With Us movie. She was not employed or even contracted by Wayfarer. So Wayfarer's own policies are irrelevant. That's my opinion anyway. She has also explicitly stated that employers must investigate promptly regardless of whether the complainant chooses to participate. Second, the CRD guide provides that an employer should counsel against retaliation, and that part of the purpose of conducting an investigation is that at the end of an investigation, the employer needs to take effective remedial measures to avoid additional wrongful conduct, including retaliation. I mean, clearly there was no investigation done at the time because no one felt it rose to that level. Sony did the same thing. They did not, and it's arguable that they should have investigated something, but they did not investigate anything, and that's something that Michael Robbins criticizes them for. But clearly, two companies both agreed that what Lively was complaining about was nowhere near the bar of something that needed to be investigated. At worst, it was a misunderstanding. Second, the CRD guide provides that an employer should counsel against retaliation, and that part of the purpose of conducting an investigation is that at the end of an investigation, the employer needs to take effective remedial measures to avoid additional wrongful conduct, including retaliation. Fromholz acknowledged that a core component of investigations, including every investigation she has ever conducted, is instructing the accused not to retaliate for the very purpose of preventing future retaliation against the complainant or anyone else involved in such investigation. Yet Fromholz admits that because the defendants never investigated Miss Lively's or others' concerns, Mr. Baldoni and Mr. Heath were never instructed not to retaliate. These contradictory and irrational results are indicia of unreliability in Fromholz's methodologies requiring exclusion. Fromholz's second opinion requires exclusion pursuant to Rule 702 A to D. Fromholz's second opinion fails to assist the trier of fact. Fromholz's second opinion predicts the outcome of a hypothetical investigation of harassment complaints, an investigation that never occurred, to find that Miss Lively's allegations somehow did not amount to harassment. Judge Lyman said that as well. Judge Lyman said that, and you never conducted an investigation. For the reasons discussed here, Fromholz's second opinion fails to assist the trier of fact under Rule 702A. Because it is limited to predicting the legal outcome of harassment and only harassment. This is particularly problematic given the well-established rule that a retaliation claim may be brought by an employee who has complained of harassing conduct that the employee reasonably believes to be harassing, even if a court later finds otherwise. Here, the court order did not conclude that Miss Lively's allegations did not amount to harassment, determining instead that there was sufficient evidence that she reasonably believed in good faith. It's not quite what he said. He said the jury could find that she reasonably believed in good faith. Lyman did not say that she had. They are misquoting him. Determining instead that there was sufficient evidence that she reasonably believed in good faith that the behavior she complained of was unlawful harassment, and that the Wayfarer parties understood that her complaints amounted to sexual harassment allegations. That is not what it said. In fact, they quoted what he actually says. It says it suffices for present purposes to conclude that drawing all inferences in Lively's favour, which he has to do when, assessing a summary judgment, he has to look in the light most favourable to, in this case, the plaintiff, and that was Lively. A person in her position could have understood the workplace to at times reflect a gendered and sexualized view of women and disregard for their privacy sufficient to make it reasonable to complain about a hostile work environment based on sex and gender. But yeah, that's just, Judge Lyman made a point of saying, I'm not making any comment on the merits of Lively's claims. And actually, there were some claims he said, well, individually, these are not sexual harassment, such as the fat shaming. And what was the other one? The slow dance, that's it. Slow dance. There was quite a few, actually. Lyman said, no, these wouldn't rise to the level of sexual harassment. There were some, he said, where he was like, well, it's possible, and if you put them together, maybe the jury could find that. And that is what he said. Okay, so we continue. I knew I was going to get annoyed with this report. I knew I was. Okay. Policy considerations support this rule because a rule that would allow retaliation against an employee for opposing conduct the employee reasonably and in good faith believed was discriminatory, whether the conduct subsequently was found not to violate FEHA, would significantly discourage employees from opposing incidents of discrimination, thereby undermining the fundamental purposes of the anti-discrimination statutes. Because Fromholz summarily and baselessly concludes no harassment occurred, Fromholz's legal conclusion is irrelevant to Miss Lively's good faith reasonable belief. I mean, I wouldn't go as far as to say it was irrelevant, but they do make a fair point there, because it doesn't matter whether she was harassed or not. If she has a reasonable good faith belief that she was harassed, then that is the bar to meet. Fromholz's second opinion is an improper legal conclusion. Fromholz's second opinion should also be excluded as an impermissible legal conclusion or law to fact application. Fromholz opines, based solely on grossly incomplete materials provided to her by the defendants, that a preponderance of the evidence did not support Lively's allegations. Courts routinely reject such expert testimony. For example, in Kotler, the Court of Appeal found reversible error in allowing an expert to opine on whether an employer acted for retaliatory reasons in a wrongful termination case. There, the court found that a HR expert who opined that facts were indicators that an employer discharged an employee for retaliatory reasons improperly invaded the province of the jury. Similarly, in Lipset, the district court found two experts unqualified to testify about whether conduct constituted harassment in violation of the law because that testimony usurps the prerogative of the jury as the fact finder and would not assist the jury in understanding the evidence or determining a main issue in this case. As the court reasoned, the jury, using its own judgment, must decide whether the totality of the circumstances which has been presented during the trial is enough to constitute a hostile work environment. The same principles apply here. Fromholz cannot opine on whether Miss Lively's allegations amount to harassment by a preponderance of the evidence. Only the jury can determine whether Miss Lively had a good faith, reasonable basis for her allegations. The court should reject her opinion in full. Fromholz's second opinion is unreliable. Fromholz's second opinion should also be excluded as unreliable under Federal Rules of Evidence 702 B to D, because it speculates as to the outcome of a hypothetical harassment investigation in a manner that is contrary to standards and Fromholz's own practices. Courts routinely exclude expert testimony that is speculative or conjectural, or that is formed without even endeavouring to obtain and consider all of the available and relevant information. That is precisely the case here for three reasons. First, Fromholz's methodology of reviewing hand-picked documents ignores standard practices, including the CRD guide on how to conduct a fair investigation. The CRD guide's steps include proceeding impartially, interviewing witnesses, obtaining all the facts, and making factual findings based on an objective weighing of the evidence. Fromholz admitted at her deposition that she has never been trained to assess credibility for an investigation solely by reviewing deposition transcripts in an adversarial proceeding. Instead, she has been trained, in line with the CRD guide, that an investigation requires determining the credibility of witnesses by interviewing them in a neutral investigative environment. Fromholz acknowledged that a neutral setting allows the investigator to ask questions, follow up, and dig down. Yet Fromholz conducts her own hypothetical investigation in a vacuum, making credibility determinations and thereby plainly intruding on the province of the jury, without ever interviewing any witnesses and based solely on grossly incomplete materials provided to her by the defendants that ignores Miss Lively's good faith reasonable belief altogether. Fromholz admits that she had no opportunity to do that here because she never interviewed anyone. She provided no input into the deposition questions posed to Miss Lively, even though she recognised she could have dug down in different directions. Fromholz could not even recall whether Miss Lively had been asked at her deposition about each incident she believed was harassing. Fromholz testified that when she assesses the sufficiency of an investigation, she considers whether it was conducted promptly, who was interviewed, what documents were reviewed, and whether appropriate corrective action was taken, all of which cut against any claim of sufficiency here, since none of this was done as there was no investigation. Second, Fromholz's methodology is also entirely inconsistent with her own past investigative practices. As to her own practice, Fromholz conceded that she has never before conducted an investigation in the manner in which she does here, making credibility findings using a self-serving set of documents without interviewing a single witness. Even by her very own evaluation criteria by which she evaluates the sufficiency of any investigation, whether it was conducted promptly, who was interviewed, which documents were examined, and whether appropriate corrective action was taken, Fromholz's hypothetical investigation fails to pass muster. Okay, we haven't got too many pages left now. It's only 3 or 4. Okay. Fromholz ignored key facts regarding the trailer incident. Fromholz found Miss Lively's allegation that Jamie Heath entered her trailer and saw her breasts while she was having makeup removed by Vivian Baker and Anne Carroll, contradicted by selecting portions of Heath's testimony, who does not deny looking at Miss Lively, and Carroll and Baker's testimony, who stated that they tried to cover up Miss Lively's naked body. Body? The whole body was naked now? Fromholz entirely admits Carroll's testimony that Heath could have seen Miss Lively's naked body in the mirror. When confronted with these omissions, Fromholz admitted that if she had credited Carroll's testimony, she might have had to reconsider her second opinion. Fromholz ignored key facts regarding the birthing video. Fromholz accepts Heath's version of events as to Miss Lively's allegation that Heath showed her a video of his wife giving birth nude without Miss Lively's consent. Then something is redacted. She summarily and baselessly concludes that there was no nudity in the first part of the video, which is the only part Miss Lively might have seen. Miss Lively, however, recalls seeing a naked woman with her legs spread wide. Then something else is redacted. Fromholz ignored pattern evidence that severely undermines Baldoni's credibility. Fromholz's opinion conveniently omits incidents that Miss Lively has pointed to as contributing to the harassing environment. 1. Baldoni telling Miss Lively about his own sexual experiences, including simultaneous orgasms with his wife, and asking Miss Lively if she and her husband did too, which, by the way, was one of the things that Judge Lyman also said did not constitute sexual harassment. And 2, Baldoni teasing Miss Lively about her not viewing pornography. Fromholz was also entirely unaware of Baldoni's text messages to his friends describing the 17 protections as all manipulation. She conceded that such texts would be relevant to assessing Baldoni's credibility and that they could change her opinion if there was action taken because of that. Fromholz ignored key facts undermining the defendant's narrative. Fromholz attempts to undercut Miss Lively's allegations by asserting that Lively on multiple occasions initiated unscripted kisses of Baldoni. When pressed at her deposition, Fromholz acknowledged the script expressly directed Miss Lively's character to kiss Baldoni's character all over for one of the scenes, and that for the other scene, if they discussed and planned the kiss, it might not have been improvised. Hold on, Lively in her own complaints admits that they were unscripted kisses, and she says just because I did it doesn't mean that Baldoni can do it to me. Plus, if it was in the script, that's because Lively put it in the script. Fromholz never reviewed Miss Lively's verified declaration in support of her motion for summary judgment opposition, which contradicts the very narrative that Fromholz credited. When asked whether her opinion would change based on the declaration, Fromholz replied, "I would have to go back and see if there is competing evidence." Upon being confronted with these facts, she's conveniently ignored them in forming her opinion. Fromholz immediately backtracked. She admitted that she may have changed certain positions based on these admissions, or that she overlooked evidence that could have been relevant to assessing credibility. Fromholz's opinion relied on a record too unrepresentative to provide reliable support. Fromholz is not qualified to offer the third opinion, and it separately requires exclusion pursuant to Rule 702 B to D. Fromholz's third opinion is unreliable under Federal Rules of Evidence 702 B to D because it is built on selective facts and misstates governing standards. Fromholz opined that Robbins incorrectly concluded that 1. Wayfarer should have but failed to establish closed set protocols before the birth scene, and 2. Wayfarer violated the SAG-AFTRA guidelines by failing to offer Miss Lively an intimacy coordinator for the scene. When tested, Fromholz's third opinion quickly crumbles. First, Fromholz wrongly concludes that the birth scene did not involve nudity, and so did not require certain protocols. While stating that intimacy coordinator Elizabeth Talbot testified that the birthing scene did not involve nudity, Fromholz also admitted that Talbot testified that the scene did involve a high hip profile, which is a form of nudity for which an intimacy coordinator and nudity rider would be recommended. Can you see that? They place emphasis on the word themselves. It would not be mandatory, it would be recommended. Second, Fromholz also wrongly faults Miss Lively for not requesting an intimacy coordinator before the birth scene, but Fromholz had not read documents at any point prior to her deposition, illustrating that neither Miss Lively nor Talbot knew that the birth scene would involve nudity. Lively wrote the scene, and so would not have known to request an intimacy coordinator's presence. She also glossed over that it was Wayfarer's obligation to call the intimacy coordinator to set. Third, Fromholz incorrectly concluded that the set was closed during the birth scene based entirely on Heath's testimony, which confused closing a set to the public generally with closing a set under the guidelines. Fromholz conceded that she might alter her conclusion after she reviewed Miss Lively's declaration, which states that the set was not closed to non-essential personnel for the first time at her deposition. Fourth, Fromholz misstates the guidelines by claiming that they state intimacy involved nudity and simulated sex only, but the guidelines define intimacy coordinator obligations to encompass nudity, simulated sex, and other intimate and hyperexposed scenes. This plainly applies to the birth scene, which involved a high hip line, i.e., profile nudity, as Miss Lively was positioned on her back for hours with her legs spread wide in stirrups, and at times with only a small piece of fabric covering her genitals. When confronted, Fromholz conceded SAG-AFTRA believes intimacy coordinators should be hired for other intimate and hyperexposed scenes that don't necessarily involve nudity or simulated sex. Fromholz is unqualified to provide her third opinion. Fromholz's third opinion should be excluded because Fromholz is unqualified to offer it. Fromholz has no experience with intimacy coordinators, nudity riders, improvisation of intimate scenes, or the guidelines. She conceded that her understanding of the intimacy coordinator role derives entirely from her review of Talbot's deposition transcript. Fromholz cannot manufacture expertise by reading a document. Well, I mean, in fairness, your expert is doing exactly that. Fromholz is unqualified to provide her there's so much F's. Fromholz is unqualified to provide her fourth opinion. Fromholz's fourth opinion, that there simply is no support for the conclusion that actors are harmed more by reputational damage than, for example, plumbers, is not expert testimony at all. Fromholz has no experience on reputational damage specific to the entertainment industry. Fromholz conceded her opinion is based solely on things she's read and things that have happened to people that have been publicized. Conclusion: for the foregoing reasons, the court should exclude Anne Fromholz's testimony in full on each of her opinions. And that's from Ezra Hudson. All right. So I'll move on to the next one. But yeah, this wound me up a lot. I don't know. Let me know what you think.